Okay.
Good morning, everyone. I'm going to start the roll call. We'll start with the Commissioner. Shonda Brown, Joseph Gregory, Howard,
Guys, I'm sorry to interrupt, but can somebody background is very loud. Can it be muted?
Thank you. Okay, so Shonda Brown, are you present?
Yes, I am here. Good morning.
Thank you. Jorge Martinez,
Yes, I'm here. Good morning as well.
Russell Martinez, Matthew Nye, Thomas Schneppner.
Present.
Good morning. Matthew Smith. Here. Douglas Swan. Jared Whittington.
Present.
So we have eight present.
Thank you. I just want to acknowledge that this is our first in-person meeting in at least a year and a half since COVID began. It's my first in-person meeting as chair. And I just want to thank you all for being here today and for everything that you've done in the last year and a half. I think what the ECP has accomplished is really extraordinary considering the conditions we were all working under and what the city was going through. So I really appreciate all of your efforts and the work that you've put in. It really is incredible that we can say, as an agency, oath in general, that we've been able to stay fully operational during this time and continue remotely and continuing serving the people of New York. So incredibly impressed with the team that we have and with the work that you've all done. So thank you, and it's great to finally meet you in person. I'm first going to ask for a motion to adopt the minutes for the June 10th, 2021 meeting. Thank you, Madeline. Does anyone have any corrections? Okay. I'm going to ask Joy for a call for vote to approve the minutes as presented.
Commissioner, just one correction, we have nine present. So, including Cindy. I will start by asking if anyone has any objection to the minutes for the June 10, 2021 CP board meeting. Hearing no objections,
Great, thank you. So we do have a few rules we're going to be discussing today. I'm first going to ask Olga Stats and introduce those proposed final rule, correcting and adjusting the language in both rules.
Hi, good morning, everybody. Good morning, everybody. This is Olga Stats, and I'm here with the final round for the adjustments and corrections rule that you all have seen on numerous occasions by now. And so, as you know, the rule adoption process is a long one. We go through proposed rules and final rules. So what you have before you, there's no change to what you had approved previously. This is just the final, and it will be published. So we're asking you to approve that. Any questions?
Thanks. Thank you, Olga. Hello, Russ. All right, so I'm going to ask for a motion to approve. Thank you, Madam. Joy, please call a vote.
I want to ask if at this moment, if everyone has this, whether there are any objections to approving the final that corrects language and makes adjustments to those rules. Any objections to please indicate.
So, I'm sorry, something in that room is creating some like staticky feedback in the board meeting room. Is something like wrestling by a microphone?
Yeah. Yeah, it could be that there's feedback.
Okay.
How's it now? How is it now?
It's better. It's better.
It's better, but we can't actually hear you so well. If you guys can talk a little louder.
Okay. At this
Thank you.
moment,
I agree.
Okay, at this time, I will ask if there are any objections to the motion on the table to approve the final rule correcting language in both rules. Okay, seeing and hearing no objections, this motion passes unanimously. Thank you.
Thank you, Joy. I'm now going to ask Olga Stats to introduce an important rule that some of our staff have been working very hard on. It's clarifying the procedures for remote proceedings and appearances. Olga, please.
Thank you, Commissioner. Yes, what you have before you is a rule that we're proposing to have adopted. And and as you saw by reading it, it involves allowing or making clear that both proceedings can take place remotely. And so for both the trials division and the hearings division, what had been usually exclusively in-person hearings, we propose to have them also be remote. And as you all know, the reason for this is because of the pandemic. At the pandemic, the commissioner turned on a dime basically and was able to start remote hearings almost immediately based on her own authority as commissioner. That's authority that she has in the charter. However, in consultation with the law department, they said that if we propose to continue this and extend the practice, they recommend that we engage in rulemaking. And as a result of that advice, we came up with these rules, which basically are, most of them are just taking the rules that already exist and making sure that it's clear that one can also proceed remotely. So there are a few other ones that I'd like to point out to you, but the majority of the rules are simply saying or remote, or video conferencing, or telephone, et cetera, et cetera. Now, in doing that, we also decided, based on the experience we had over the last year and a half of doing the remote hearings, we realized how things should function. And as a result of that experience that we had, both at the clerk's office and in the hearings division, we're proposing one new rule, which shows up at the end, which is section 17 of proposed rules. So it's at page 10, bottom of page 10. It's section 6-24A. And it gives all of the specific processes and protocols that have to be used if an attorney or a representative wants to proceed remotely. So that's the only new rule that you're seeing here. Everything else is basically an adjustment of the rule to allow us also to have remote hearings. So, and I'm happy to answer any questions you might have about the new one.
I just want to add to that a little bit, just so you all know. Well, first of all, since March of 2020, we've done almost 200,000 cases remotely, and it's been incredibly successful. I don't think I've received one complaint from an agency or an attorney where I responded regarding the procedures that we've put in place. So it's really been remarkable how well we've been able to transition to primarily telephonic hearings. And come September, which is now only 2.5 weeks away, we intend to start offering in-person hearings, assuming somebody is pre-approved for an in-person hearing. And that pre-approval won't require any sort of special argument or rationale. They just need to request the in-person hearing 3 days in advance. But if they show up and they haven't made that request, then we'll assist them in rescheduling an in-person hearing or setting up a telephone. But come September, we will be offering in-person hearings for those that would like it, at least in some of our locations, not in all of our boroughs, but in, at least in Manhattan and Long Island City. But come October, November, we'll be offering it like in all locations. So we are moving towards offering in person for every location shortly.
Hello?
Hi.
This is Shamanda Graham. I'm sorry to interrupt. Commissioner, it is a little bit low, so I just like to repeat what I heard to ensure that I heard it correctly. Again, Shamanda Graham from Department of Buildings. Did I hear you just say that in September, come September, in-person hearings will be offered to basically the public, the named respondents, if they request an in-person hearing? But I did hear you say something about October or November. Would that be expanding to the 5 boroughs? I just want to make sure I understand.
Sorry, and I'm going to speak a little bit louder and into the microphone. So,
Thank you.
in which boroughs are we doing in September? Right, so come September, we will be offering in-person hearings for those that requested in advance in Manhattan and Long Island City.
Got it.
And we'll be expanding to other boroughs later in the fall.
Understood. I heard you correctly then.
Questions?
There was a note in the last section you just pointed out about 25 cases per council.
Yes,
Can you explain that just as a scheduling issue? What that was the
Yes.
appropriate number?
yes, that's the number we found that can be heard in one day. So when people have tried, because a lot of this was trial and error, and the numbers that you see here are numbers that really, from experience, we found that they work properly. So at the beginning of the process, we were not sure exactly how many cases individual attorneys could handle. And so we would allow people to do a lot of them. And what would happen is that they wouldn't get through the cases in one day, which would force us then to push, to create an adjourned date and to push matters forward. So this number was basically the average number that we found that most attorneys could get through in a day, so that those hearings could be completed. One of the things that we have to always keep in mind is that we try not to multiply the times a matter comes before a hearing. It's not efficient. We try to have one summons heard by a hearing officer one time and have that determination. But when we allow things to be pushed over or have to be redone, that's a duplication of effort, and it's a duplicate, and it's using too much time and resources to do the one thing. So this number basically is the number that self-generated based on the experience we had over the last 15 months. Yes,
Olga, what was that number?
it's 20, so.
Approximately 25.
25.
Okay, thank you. That's my number too. That's why I was asking.
I'm sorry?
Shamanda Graham,
okay.
Department of Buildings. We looked at this a long time ago.
Yeah, so
We looked at this a long time ago, and we have the same, a similar number. We don't think any person can handle more than 25 cases in a day.
Yeah, that's exactly, so I'm glad to know that it's confirmed. That's what we came up with as well. Yes, Madeline?
Madeline, I just have a question because of the 25 summons limit in
Mhm.
listing cases. Typically, are many more summonses than that? Usually one representative comes in, or let's say a group of 200 summonses, would they be impacted by this?
Yes, what happens is that this is for individual attorneys. And what happens, most of the time, the reps and the attorneys work in firms. So for example, you have firm A, they have 10 attorneys. Each one of the 10 attorneys can have 25 cases. So the thing is, it's the 25 per individual attorney. But if a law firm has 10 attorneys, they can do 20. So the normal volume is being handled, but it's being handled in person by person in a way that we can control the flow.
Right, no, I understand that, but. if-
Madeline,
200 summons.
Madeline, this is Amy Slivka from Amy Slivka. If you issue a posting case, for example, and it's all to the same respondent and it's 200 summonses or such, we would allow the respondent to sign in for those cases because it's one charge and we can handle that type of situation. This is really where it's 25 separate cases, 25 different issues. So, but there are exceptions even that. So for example, for Shamanda Graham, if it's a failure to comply and the person received 20 summonses with the same issue, we'll let them come in plus a few more. So it varies, but the sense is one attorney cannot handle 25 individual cases, more than that any day.
Okay, understood. Thank
Amy?
you. We need to clarify.
Amy, this is Shamanda. That is great. That sounds good, and I understand the concept of the issue. I do have one question, and it may be directed to the commission. I'm not sure. I know that the respondents will be able to elect to come in person. Does that have any bearing on the enforcement agencies, or are we able to continue to appear remotely?
Right, yeah, it's up to the discretion of the agency.
Got it.
And
Thank you.
the idea would be, since we know in advance which cases are going to be heard in person, the agency will be informed, you know, if they're interested in knowing whether the person's coming in person or by phone, they can make that determination as to whether they want to appear in person.
Right. I just, yeah, Shavonda, just eventually included with the list that Lou sends daily, we will start to include those cases that are scheduled for in-person hearings for the respondent. I mean, again, it's your discretion whether to come or not.
Got it. So we'll have a flag, but as far as we get the cases from Lou, and that all makes sense, but we get those cases one day before the hearing. So for us, even though I know we have the discretion to come in person, really the 1 day notice, can you imagine? You deal with the hearing officers.
Shamanda, you will get this list as we have it. It'll be updated daily.
Okay.
You'll get the list as we
Okay.
have it. So you should be
I
getting it
appreciate
probably
that.
starting around next week.
Yeah, I'm not even questioning that. I just wanted to note that you and I both know we can't get any of the attorneys to come in with only 1 day. But okay, thank you.
So Madeline just raised a good point, which is that the wording in this rule sort of, it states summons and then later on states cases. And does it make sense to make it more consistent across the paragraphs?
So, Madeline, if I'm understanding you correctly, I'm looking at on page 11, I'm looking at subsection B and subsection C. It says, no one registered representative or attorney by remote means on a single hearing date for more than 25 instead of cases, instead of summonses, you prefer the word cases, yeah, right? And also for C, for each group of up to 25 cases to be heard on that date. Okay, but the rest
So
of
and then it says that later it says 25.
yeah, I just mentioned C. I just mentioned B and C. And then, however, for example, for 4, going up to 4, the use of the word summonses is correct, right? Because it says the attorney or registered representative calls in for their first scheduled hearing no later than the earliest scheduled hearing time is set forth on the summonses or rescheduled notices. So that use of summonses. So what I need to look for when we go through this rule is just when we're talking about the representation. So that's when that's when you recommend that I use the word cases rather than the word summonses. Is that correct? Correct. Okay. Thank you. Okay, so the last line in D as well, that would be cases, right? Once a registered representative or attorney is assigned to appear on a group of cases, a different registered representative or attorney may not appear in that case. Is that okay? So far I see suggested edits in B, C, and D for summonses. Right, Madeline? Correct. Thank you so much. And does anyone else have any questions? Thank you.
Tom, did you have a question?
No, I'm just parsing the language of the basis of this discussion. I think you could actually leave it. I think we just need to kind of take a minute.
Yeah.
Yeah. That's
So
fine.
I'm gonna,
Take a minute. People want a little bit of time right now to review it.
I think that would be efficient, yeah.
So we'll just pause We're going to pause for 2 minutes so people can review the rule more thoroughly.
Tell me.
And then, oh, and I found another one.
Of course, that's.
Look, what do you think now? The attorney or registered representative submits only one list for hearing date and submits that list electronically pursuant to the tribunal's direction to a recipient designated by the tribunal, regardless of the county in which the cases were scheduled. Are we good? Okay. Yes. Okay. Okay, terrific. Thank you so much. Does anyone else have any questions? Additional questions?
My only question about the time period, it sounded like when the agency says they only get 1 day notice here, when we're talking about a 3 day notice, is that for the respondents?
That's for the respondents. The respondents have to notify the agency. But when they're coming in with a volume of cases, they need to notify the agency at least 3 days in advance in a form that where the agency can actually process process the cases and ensure, and it's one of the things we need to do is ensure that the representative is actually representing that person, because that causes a lot of friction and difficulty. So it takes about 3 days. That's another trial and error time frame. It takes about 3 days for us to do this properly. So that's why we're putting in that 3 days.
Good, okay. So thank you for those suggested edits. We are now going to ask for a motion to approve with the caveat that those edits will be made to the draft. But we are trying to do this as expeditiously as possible because obviously we want to get these rules in place as soon as possible.
Tom Schmidt, Harris, citizen member. You need to just get black on it.
Yeah. Is there a motion? Thank you, Madeline. Ask Joy to take it.
At this time, I'm going to ask, instead of a roll call, we're going to ask if there are any objections to the approval of the proposed rule that clarifies remote hearings and appearances. Do we have any objections? Okay, at this point, this motion is approved unanimously. Thank you.
Hello, Olga, this is Shamanda Graham. I just want to note that I can't vote because I'm on via telephone. So I just wanted to make sure that's noted. I'm not sure if I should be abstaining. And then I'm so sorry for being a bit behind. I am on the phone. So I did have one question. It doesn't require a change, but when the respondents notify the tribunal for the cases that they are intending on coming in on, is it possible to maybe have in the rule that they also notify the enforcement agency? So that way they take some of the burden. Amy, I am thinking that some of the burden can maybe shift from to the respondent so that everybody's aware that they're coming in on so many cases. So that's a thought and a comment. Maybe we can adjust the rule.
Shamanda, as far as that goes, it's hard for them to send you the list at the same time they send us the list because we actually check the list to make sure that they can appear on those 25 cases. So,
Oh,
yeah.
got it. So what
and
they send you, they may not appear on. I understand.
And I just want to make clear, I just have a question actually, since you raised it. Cases equals summons. I mean, we're just using the word cases as opposed to summonses, right?
Amy, can you say that again? I didn't hear you.
Are we all agreeing that cases is the same as summonses?
I think that the point that Madeline raised is cases really give the connotation that they're separate matters.
Okay.
If I just use, because I think that the point that Madeline's trying to make is that she might have a situation where it's the same violation on 200 summonses, like those posting things. And she doesn't want there to be a misinterpretation that you can't do the whole 200 same violation in the same day. It's the same respondent, the same charge, the same everything. So the only reason we're using the word cases is just to give the connotation that it's separate matters, not just the physical summonses. Because as you said, there are situations where you will hear a block of 200 summonses at once. So I think that that's just like the compromise language that we're coming up with to give the indication that we're talking about separate charges and separate stuff is going on. So we want to limit people, individual attorneys, to separate charges, 25 separate charges, 25 separate things, basically.
I'm sorry I'm bringing this up late, but the problem is sometimes a summons has more than one charge. And I don't know how that would impact it. And I sorry I did not, I didn't get that.
Yeah, you know, somehow, even if it has one charge, I suspect, this is just my opinion at this point, if we use the word case, we're still covered. Because it's broad enough that we can have two charges in one summons, because it's a case. It's like, it's one respondent with 3 charges and 1 summons, that's still a case, right?
Okay.
But when we say summons, we're talking about an individual thing. So I think that case is a safer word.
Okay.
And I just want to note for the record that Shamanda has an approved accommodation, so your vote does count.
Mr. Shuby, I wasn't here when Shimon abstaining from this vote.
Shamanda,
Yes, I'm sorry, guys, for coming in so late. I am here. I'm so sorry for coming in so late. Shamanda Graham, Department of Buildings. When I say late, I just mean with my comments to the rule. I see we got this last night, and I'm kind of on one leg, so that's why I have my reasonable accommodation. But I understand your point, Amy, about them not being able to notify the issuing agencies. But I do take note that the other issue you're raising, issue versus case, we should be really, really, really careful. And we may even want to add some language that clarifies. And it is going to be very hard to word it unless you guys think case suffices. But to clarify that, hey, if you have 25 or 15 summonses and they're all failure to comply as it would relate to DOB, then that would be considered one issue because there's only one problem. And you will need to deal with the fact that a summons from DOB and other enforcement agencies may contain more than one violating condition. I mean, that's the difference between issuing 10 summonses and 1 in some cases.
Well, Shamanda, though I see your point, but I think that case is the safest word for us to use because we can it's more elastic than the word summons. And also the word issue doesn't appear in this rule. So, and we kind of specifically avoided words that focus on the substance of the violations. We're just focusing on it's a case. It could be one summons with 2 charges in it. It could be one summons with 1 charge against this guy, and then he has another. So I think that the word case gives the agency, and because one of the things that we have to keep in mind when we do rules is that you can't cover every situation. You always have to give flexible enough words to allow the agency to kind of move around a bit based on what's actually happening on the ground. And I think that in this situation, the word case is probably the safest one, but I'm happy if you email me something, I'm happy to take a look at it and see, and then discuss it with the law department and see what we can do about it. But I think at this point, maybe staying with case would be a good idea, but I'm happy to get anything, to take anything, you email me and discuss it with you.
Okay. Well, for my team, it's fine. Just to be clear, for Department of Buildings, this is fine. The way that it's worded. I'm thinking about respondents. They may play with the wording here.
Okay, thank you so much.
So Shamanda, just to clarify, you're voting yes? On the vote
I'm
we
sorry,
just-
I can't vote. I can't
Yes,
vote,
you can. I
unfortunately,
just
guys.
stated you can vote.
I can?
Yes.
Because you have a.
Oh,
You have an
well then,
accommodation, yes.
okay, well then I'm voting yes. Yes, I'm fine with it.
I'm now going to introduce the proposed rule repealing oaths sanitation penalty schedule by Olga Stats.
Thank you, Commissioner. Yes, as you know, since approximately 2016, OAS and ECB has been divesting itself of all penalty schedules. And the majority of the penalty schedules are now no longer in OAS rules. They are now within the rules of the enforcement agencies. We have just a handful left with sanitation as one of the rules. Sanitation, the Department of Sanitation is putting together its penalty schedule. And in order for that penalty schedule to take effect, we have to be able to repeal ours. So this is the first stage in the repealing of the oath sanitation penalty schedule to allow them, and we'll be coordinating with Department of Sanitation so that our complete repeal would take place as their penalty schedules are adopted. So this is the first stage of that. If you have any questions, I'm happy to answer them. Thank you. Is there a motion to approve?
Thank you. Thank you, Madeline. I'm going to ask Joy to do a roll call vote.
Thank you, Commissioner. And to clarify, for this particular proposed rule, I'm going to just ask if there are any objections to OAS repealing its sanitation penalty schedule.
This is Tom Spector, citizen member. I'm not objecting.
Thank you. So we have one abstention. Any other opposed or abstaining from this vote? Then the motion does pass. Thank you.
Thank you very much. I'm now going to introduce both resolution to approve a temporary program to resolve outstanding Environmental Control Board judgments by Sam Solomon.
Thank you very much, Sam Solomon, Chief of Staff and Special Counsel at both. I will read the resolution because it's quite brief, and I want to make sure everyone has a chance to hear what's in it. And then I'll make a couple of notes for your background on the purpose of the resolution. Pursuant to Local Law 81 of 2021, which establishes a temporary program to resolve outstanding judgments imposed by the ECB, the board hereby concurs with the Commissioner of Finance establishing a temporary program to resolve outstanding judgments for a 90-day period to be effective during the fiscal year that commenced on July 1st, 2021, provided that such period may be extended for an additional period of 90 days by rule of the Commissioner of Finance, if such commissioner determined that such an extension would encourage further resolution of outstanding judgments, generate revenue for the city, and reduce the amount of outstanding debt owed to the city. This temporary program will permit respondents who are subject to default judgments to resolve those judgments by payment of base penalties without payment of default penalties and accrued interest. It will also permit respondents subject to judgments entered and docketed after an adjudication and finding of violation to resolve those judgments by payment of 75% of imposed penalties without payment of accrued interest if the judgment was entered prior to March 7th, 2020, or 25% of the imposed penalties without payment of accrued interest if the judgment was entered and docketed on or after March 7th, 2020.
And just to be clear, that language comes from the bill. And I wonder if it makes sense to circulate a copy of the bill, which we can do, which was passed by the city council maybe 2 months ago.
The time period itself is in the bill? That's correct. So the 90-day period is the one that was established by law with the possibility of 90 days of extension by the Commissioner of Finance. And just a couple of notes to add on this. The law was passed by the council unanimously in June. The program is required to be run by the Department of Finance during this current fiscal year. A start date has not yet been announced publicly, but the program has not begun yet. It only applies to debt owed as a result of judgments imposed by the Environmental Control Board. Prior programs similar to this one were operated in 2009 and 2016. The local law requires the Department of Finance to perform public education about this opportunity for respondents who owe debt to the city. And once those public materials are made available, oath will ensure that interested respondents who inquire with our staff are informed about the opportunity. And then lastly, the city has asked the ECB for approval of this measure in order to ratify the authority of the Department of Finance to offer to discount this debt owed to the city under the local law.
Any questions? Questions? Matt?
Can you just further explain how you're going to get the word out and what that looks like?
Yes, this program, because it's run out of the Department of Finance, we will be referring people to the Department of Finance to actually make their applications for amnesty. But we will make information available both on our website, and then we also plan to have physical materials available at our offices that respondents will be able to take with them.
We do a lot of outreach with elected officials and their staff in various places through our Deputy Commissioner of External Affairs and our Deputy Commissioner of Intergovernmental Affairs. So I'll make sure that they're.
But there's no notice sent to everyone who has a judgment or anything.
No, not to my knowledge.
Well, once you respond, you just send around the material.
Yes, absolutely.
Yeah, I mean, I think it's worth having conversations with the mayor's office to make sure that this is being done centrally because it's multi-agency and they should be getting the word out. So we'll make sure to do that. Any further questions? I'm going to ask for a motion to approve the resolution. Thank you, Madeline. I'm going to ask for Joy to call.
Thank you. Okay, and so we're going to just ask again for any opposition to the approval of the resolution that will approve the temporary program to resolve outstanding ECB board judgments. At this time, I'll ask if there are any opposition, abstentions. Not seeing or hearing any, the motion is approved unanimously. Thank you.
Great, thank you. And Peter Schulman will be circulating the bill. So you should be getting an email shortly. I'm now going to ask Kelly Corso to introduce the pre-sealing reports.
Good morning, everyone. Can you hear me?
Yes.
Great, thank you. So we have 4 pre-sealing reports today for the board. All of them involve backflow violations. One of them is going to be a recommendation for a water shutoff, so I'm going to do that one last. The other 3 cases, the hearing officers agreed with DEP's recommendation that there be no further action for these because the respondents provided evidence of compliance at the hearings. So those are the first three. The water shut-off case is, this case goes back to April 2012. The respondent is 2710-2714 Broadway LLC, and the premises is located at 2710 Broadway in Manhattan. And it is occupied by a city MD urgent care and an English language school. So back in April 2012, DEP issued a commissioner's order for the respondent to install backflow prevention device, and it warned the respondent that if they did not comply, that the water would be shut off. Then in August of 2014, DEP issued a summons to the respondent because the respondent had failed to comply with the order. The respondent did not appear for the hearing, and a default decision was issued to the respondent. Then in June of 2016, the board issued a cease and desist order to the respondent because respondent still had not complied with the commissioner's order. The cease and desist order directed the respondent to appear for a special hearing on August 13, 2016, to show why the water supply to the premises should not be shut off. Respondent did not appear for that hearing, and the respondent, in fact, did not reach out to Oath to reschedule the hearing until November 2019. After a number of reschedules, the first special hearing occurred on October 27, 2020. Since then, the case has been adjourned 6 times for the respondent to comply with the commissioner's order. Respondent's representative was advised at the hearings that the water would be shut off if the respondent continued to ignore the order to comply. At the last hearing on July 6, 2021, the respondent's representative offered no evidence to indicate that substantial progress has been made towards compliance, and to this date, the backflow device has not been installed. So DEP recommended at the last hearing that the water service to the premises be terminated since the respondent has failed to comply with the order. And based on the lengthy history of the case and respondent's continued failure to comply with the order, the hearing officer agrees with DEP's recommendation that the water to the premises be shut off. Questions?
Hi, this is Tom Spetner, system member. Has respondent's representative given any dilatory behavior? I don't, Kelly, can you hear me?
No, Tom, can you repeat what you said?
Yeah, really just briefly, have they given any excuse or kind of explanation for their dilatory behavior?
It doesn't seem like it. And in fact, at one point they said that they wanted an adjournment to get their final test results approved for the backflow prevention device. And then they turn around and the next hearing, we find out that they actually haven't even had it installed. So there's a lot of, it seems like that the respondent may not be communicating much with the representative who's showing up for the hearings.
And just one other question, the respondent is not the same party as either the school or the doctor's office, is it?
I don't believe so.
Okay, thanks, Kelly.
Okay, thank you. I'm going to ask if there's a motion to approve.
I just want to ask a question, understand. So water shuts off, even though the doctor's office is involved, so they lose their water as well, even though it's the landlord who didn't take the action. But they made aware of what's going on before this happens.
I'll have to defer to Russ on that one. Russ?
Yeah, Russell Picciuti is with DEP. So once we get the board letter, copy of the board letter, directing that the water be turned off, we would have inspectors go to the premises. And basically, I mean, we're not going to go, there's a process in turning the water off. The street and the sidewalk have to be marked, and it will not just be that somebody will show up there and turn the water off. They will have sort of one last ditch opportunity to come into compliance before the water gets cut off.
And the tenants themselves get notified? Who, the occupants of the building, it sounds like.
The tenants will be, yes, we would send an inspector there. We have notices that say the water to this premises will be terminated on Thursday, whatever it is, due to failure to comply with cease and desist order. They would be posted on the premises, so the tenants will be aware.
Anything else? Is there a motion to approve? Thank you, Madeline. I'm going to ask Joy to call the vote.
Thank you, Commissioner. This time, I'm going to ask if there are any objections or extensions to the motion that we approve the 4 pre-sealing reports as presented by Kelly Corsa. Okay. Hearing and seeing none, motion passes.
Thank you. I'm now going to ask for a motion to go into executive session to discuss some recent cases. Thank you, Madam Smith. The motion to go into executive session is approved. So everyone other than both ECB staff and ECB members must leave the room or sign off until a motion to return to public session.
If you're not oath and you want to stay on, I will move you to a waiting room and then bring you back once the executive session is done. We're good.
Okay, great. Thank you. Does the board have any additional questions? Yes, Madeline. So the proposed dates right now are October 4th or October 5th. Is there a date that folks prefer? We would bring a cake, but really none of us are eating. I would have brought like donuts today, but like I didn't think it was appropriate for us to be eating with the masks. Okay, great. Great. So the next board meeting will be October 5th. Are there any comments from the public? No. I'm going to ask for a motion to adjourn the meeting. Thank you, Tom. The meeting's adjourned. Thank you.
Thank you.